Hi, my name is Sharmeen Anwar. I'm an attorney with Cobb Legal Aid, and I'm also the lawyer in the law library. This is a clinic that Cobb Legal Aid puts on every Monday through Wednesday from 9 a.m. to 4 p.m., where I provide free consultations to qualifying individuals on qualifying matters. And today I will be giving a presentation on the basics of estate planning. So just some background on Cobb Legal Aid. We are a nonprofit law firm that provides advice, free advice, and services to low-income individuals on a variety of civil legal matters. The issues that we commonly assist with are housing, family, public benefits, and education. So if you are ever in need for any of those types of civil legal matters, if you need assistance on them, please do give us a call. We do intake and screening by phone 9 a.m. to 12 p.m. Monday through Thursday, and you could also do an online intake for non-urgent issues. Just a disclaimer, as I'd mentioned today, I am giving a presentation on estate planning in Georgia. This is a general presentation. If you are seeking specific advice, please do seek legal assistance about your specific matter. So estate planning, what is it? It is an umbrella term that refers to a variety of legal documents that helps you plan for your future. It allows you to make plans about your assets, about yourself and your health in the event that those decisions need to be made. Without an estate plan, Georgia law would determine how your property is passed. So this is exceptionally critical. If you have significant assets and you have specific preferences about how you would like that property distributed, you would want to have a will, and you would like to do that estate planning so that you can make sure your preferences are taken in, so your preferences are actually executed. The types of estate planning that we will be talking about today are a last will and testament, advance directive for healthcare, and a power of attorney. So the first document that we're talking about is a will. A will is a legal document prepared by an individual in which they declare how their property shall be distributed after they die. And some common words that you probably hear when you probably talk about a will are testator and executor. The testator is the individual who is preparing the will. It is the person who that will belongs to, essentially. The executor is the personal representative that the testator has nominated to carry out their will. This is the person who the testator likely trusts that will actually carry out the will in accordance with their wishes, someone who will go through that entire process of collecting assets and making distributions and paying off debts. In Georgia, there are certain requirements to have a valid will. The first being that it must be in writing. Georgia generally does not acknowledge oral wills, so your will would need to be in writing. It can be printed or it can be handwritten. The will must be signed by either the person making the will, so the testator, or by someone designated by the testator. So there's a situation where you can imagine if someone has some kind of limitation that would prevent them from signing it themselves. Well, if there's someone that they designate to sign on their behalf, that still counts as a signature. There are also some situations where you can imagine if the testator can sign it, but perhaps they need some assistance. So they can have someone help them sign, guide their hand, and do that signature. And that still meets the requirements typically of a signature for a will. The testator must also have capacity. This is known as testamentary capacity. You have testamentary capacity when you are capable of rational decision making and you are of sound mind. Now, this is really important because sometimes there are certain situations where an individual may not have sound mind or rational decision making the entire time. There may be periods of time where they do have that rational making and decision making. And as long as they prepare their will when they are within that capacity, when they are within that rational decision making and of sound mind, then they have testamentary capacity. Additionally, in order to have testamentary capacity, they must also not have prepared the will under undue influence or coercion. So there are situations where you can imagine if someone is at end stage of life and perhaps a loved one or a friend or a business partner is encouraging or maybe almost forcing the individual to prepare a will. It could be where they are standing over that person as they are maybe on their hospital bed and saying, you must pass this particular asset over to me or to XYZ. And that could be seen as coercion. If in fact there is coercion or undue influence, then the individual does not have testamentary capacity. The testator, so the person preparing the will, the one whose will it belongs to, must be at least 14 years or older. And the will must be attested by witnesses who are at least age 14 or older. And they must be in the testator's presence and at the testator's express direction. So the witnesses, the testator must know who the witnesses are and must be okay with those individuals being the witnesses. A common question that we're often asked is, I'm a beneficiary of the will, meaning the testator is giving me a gift under the will. Can I still serve as a witness? Well, you as a beneficiary could serve as a witness without losing your gift, so long as there are two other disinterested witnesses witnessing the will. So essentially you could witness it, but if there are not two other disinterested, basically witnesses who have no claim, who have no benefit or gift under the will, as long as there are two other disinterested witnesses, then certainly you as a beneficiary could witness it without losing your gift. But you could risk losing it if there aren't two other disinterested witnesses. What happens if those requirements are not met? So what happens if any one of those requirements are not met? Signature, age 14, attestation, in writing. If one of those are not met, then the will is invalid. When a will is invalid, it's almost as if that will never even existed. So you have to then pass that property through intestate laws. How would one go about showing a will is invalid? Well, something that we see commonly is a will contest, where someone will contest the validity of a will. They're basically making this formal objection in court saying that this will is not valid. If in fact the will is not valid, then, as I said, the property will pass through intestate succession. Intestate just means that someone has passed without a will. When that happens, usually a loved one, whether it's a spouse, surviving children, or a close friend, will petition the court for letters of administration. This is the specific, filing you have to file in the courts, like this document that you file, petition the court saying, look, this individual died without a will, but we need to be able to manage their affairs. They have assets, they have debts, we need to be able to close out their estate. So we are petitioning the court to essentially administer it and become the administrators of the estate. Usually, as I said, it's a loved one who will file this petition and ask the court to be the administrator of the estate. They have to follow the rules of inheritance. So since there is no valid will, they have to follow Georgia's laws about how the property will pass in the absence of a will. Now, these rules are very, very general, and I'm just going to go over them briefly. They can get complicated, so it's important to consult with an attorney if there is any confusion as to how this would pass. So if the deceased has a spouse and or kids, the whole estate goes to them. If you had a child who died before you, then their share will be split amongst their children. I want to take a moment to explain this a little bit further. When a person dies with children, but one of the children died before the parent, sometimes people think that that child doesn't get anything because they died before that parent. That's not necessarily true. What the court requires you to do is look at that child and figure out whether that child had any heirs themselves. Was that child married? Did that child have any children? If that's the case, that child has surviving heirs. So even though that child is no longer living, that child's surviving heirs would receive their share of of the gift. So if you die with a spouse but no children, the spouse will inherit the entire estate. If there are children but no spouse, the children will split everything equally. So if you've got 4 kids, they'll all be split equally. This includes adopted and biological children. And I also want to take a moment to emphasize the importance of legitimation here in Georgia. So in Georgia, when a child is born out of wedlock, the father must petition the court for legitimation in order for that child to be recognized as a legal heir of that child. So if a father passes intestate without a will, then the administrator would have to figure out who the heirs are. If that father had a biological child that they did not legitimate, then there's a serious issue as to whether or not that child is the legal heir. And this is often very difficult because sometimes there is that strong relationship. The father and child have lived together and they've maintained a very strong relationship, but then the child finds out they don't receive anything because they were not legitimated. So it's very important to legitimate and make sure you establish those legal relationships with your children, especially in these situations of intestate succession. If someone passes with both a spouse and 1 child, then they will divide the estate equally. If there is a spouse and more than 1 child, then the spouse would get a third and the remainder would be split amongst the children equally. So what happens when someone dies without any spouse or children? A lot of times people think, well, the person who died didn't have spouse, didn't have children, so then the property must go to the state. Well, the rules of inheritance say if there's no spouse and no children, then first you look at if the deceased has any living parents. If they do, then the estate goes to them. If they do not have any living parents, then the estate goes to the deceased siblings. If you do not have a spouse, children, parents, siblings, then the estate is inherited in the order of grandparents. If no grandparents, then split between aunts and uncles. If you have any deceased aunts and uncles, their children will inherit their share equally. If no aunts and uncles, first cousins will split your estate. So there's a long list of rules of inheritance. There's actually an heirs determination worksheet that you can go through and figure out who the surviving heirs are. In Georgia, if you die without a will and assets left over after your death will go to your living relatives. If there are no living relatives, then it would go to the state. So the next estate planning document that we will talk about is a power of attorney. And a power of attorney is a legal document that allows an individual to make decisions for another person. The person who is essentially making whose power of attorney it is the principal, and the person who they're giving power of attorney to is the agent. It's essentially allowing the agent to step in the shoes of the principal to make the same decisions on issues or on matters that the power of attorney grants them power to make. So what are the requirements for a power of attorney? Well, it must be signed by the principal, it must be witnessed and notarized. What are some examples of what are some examples of subject areas people grant a power of attorney over? Well, we often see it on real property, on bank accounts, financial institutions, and operations of entity or businesses. The reason why this is important often is because there may be a situation where you need someone else to access your bank accounts, or you need someone to access your business to be able to make decisions when you're not able to. And a lot of the times, actually, these banks often will not give any access to an individual not authorized in the absence of a power of attorney. So these power of attorneys allow to have a kind of a streamlined access to these accounts if needed. There are a few different types of power of attorneys. The general power of attorney is a very broad kind of power of attorney, grants broad powers to the agent, covers a wide range of actions and decisions, and it is ideal for general management of affairs, but it does cease to exist if the principal becomes incapacitated. So think of this as the most broad sense, a general power of attorney. A durable power of attorney will continue even if the principal becomes incapacitated. And then there's the springing power of attorney. So the general and durable power of attorneys become effective immediately. As soon as they are witnessed, notarized, signed, they are effective. But a springing power of attorney is really only effective when there's a condition that has been met. So it springs into action when the condition has been met. Usually you'll see this when the principal will say, I only want this power of attorney to be granted if I become incapacitated. So if that person is found to be medically incapacitated, and then the person who's been nominated as the agent can use that power of attorney to handle whatever affairs. This is a bit more restrictive, and it's really meant to be used when it's actually necessary and not just effective immediately. Unlike a will, where it becomes effective upon death, a power of attorney terminates at the time of death. So sometimes people think, well, I have a power of attorney for the person who died. I should be able to access their bank accounts. I should be able to pay off their bills or manage their affairs. But no, unfortunately, a power of attorney does not allow you to do that even beyond death. That is very important because a lot of people will come to me and say that the bank won't let me access the deceased accounts. And I'll say, well, because it terminated. There are other ways that a power of attorney may also terminate. You can revoke it. So the principal can say, well, I'm revoking this now. And so this power of attorney is terminated. If no agent is available, then the power of attorney is also terminated. So we often advise people to have a successor agent. So you can name a primary agent, that this is the first person. But if that person should fail to, be a power of attorney, to be an agent, or, if they die or something happens, then there's someone who you nominated as the successor agent. So if you've not nominated a successor agent, and let's say the agent you did nominate has passed or does not want to do it, then you don't have an effective power of attorney. There are also situations, for example, if the power of attorney was prepared when a couple was married and the agent is the spouse, but now that couple has divorced. The ex-spouse is no longer the agent, and if there was no successor agent, then the POA becomes ineffective, right? Because there's no successor agent, there's no available agent to basically make this POA effective. The next document that we will be talking about is the Advance Directive for Healthcare. This document outlines instructions and future wishes for your healthcare and allows you to nominate an agent to act on your behalf. So you can nominate a healthcare agent, express your medical care and treatment preferences, name a preferred guardian, and share your final and funeral arrangements. You don't have to do all four of them in Advance Directive. You could nominate an agent without doing your treatment preferences, or you could do your treatment preferences without nominating an agent. This Advance Directive is critical for many reasons, but largely because it sort of takes away that burden and stress and this kind of potential argument amongst family members in the event you do become sick and unable to communicate your wishes. So it allows you to, one, nominate an agent. So if you've not chosen your treatment preferences, at least your family members know that you chose one individual to make those decisions for you. The other thing is that it would also maybe, if you've given your treatment preferences, then it doesn't leave any room for uncertainty. Your family members know exactly what you want in those situations. So it really relieves a lot of stress and burden amongst your family members. It's also helpful because you can also nominate a guardian. So sometimes guardians become necessary when someone is unable to care for their health and safety. And if it is found that you need a guardian, well, if you have nominated someone, then at least that's the person that should be considered as your guardian if one is necessary. And it also can allow you to, say what you'd like as your funeral arrangement or your final arrangements, whether that's cremation or whether you'd like to be buried or where you'd like to be buried. So it does allow for you to it gives you a voice in a situation where you may not have a voice. Unlike a will and a power of attorney, the requirements for a valid advance directive are not as strict. You just need it to be signed and witnessed. As I'd mentioned, the importance of an advance directive, it really does reduce burden on the family. it does allow for autonomy over personal health care decisions, because you never know what may happen, and at least you've been able to say, this is what I'd like with my body, this is what I'd like to be done with my health care, in the event that I cannot make those decisions. Again, it gives clarity about funeral arrangements, it gives clarity to your family members, it allows for clarity in unexpected situations. It also gives authority to your agent. So kind of going back to what we were talking about, what you often see happen is family members will fight about what the right decision is, or who gets to be the one communicating with the physician. Physician will not communicate with 10 family members. So if you've prepared an advance directive and nominated an agent, it sort of gives that power to your agent to say, I'm the person that has to be the one communicating, that has to be the one making those decisions. As I'd mentioned, the requirements for a valid will are not as strict as a power of attorney or will. You just need to have it signed and witnessed by 2 witnesses. You should make a copy as well with the will and the power of attorney and provide it to your agent, or in the situation of a will or power of attorney, provide it to the executor and the agent in that situation. Especially with the advance directive for healthcare, you should provide a copy to your healthcare facility that treats you. If you do wish to withdraw your current directive, you should fill out a new one that expresses your current wishes, and provide everyone that you provided the old version to, provide them with the new version of it. And that goes the same with a will or with a power of attorney. Always provide copies to the people who it implicates and involves, and then if you do revoke it, or if you make changes, make a new one, you should also give those to the appropriate people. Something I want to briefly touch upon is the probate process. So this is kind of going back to wills. So you often hear people say, well, I have to probate. Well, what is the probate process? So basically, when a person dies with a will, you usually need to have that will probated. And it's the process that gives the personal representative, the executor of the estate, to have authority to gather all the deceased assets, pay off any debts and taxes, and then give the remaining assets to the people named in the will. So that's really what the probate process is, actually. It's essentially getting the assets, paying off the debts, and distributing the gifts to the beneficiaries. Just briefly going over the process, you would file the will with the probate court, and you would petition the court to start the probate process. You collect all the estate's assets. Again, you pay off the debts, and you distribute the remaining assets. And this, people always ask, do I need to probate? And in Georgia, you don't always need to probate a will. There are circumstances where maybe it's not necessary. So even if there is a will, probate proceedings may not be necessary if the deceased did not own any assets in their own name. So for example, if they owned it jointly with someone else, well, then it would go to that other person, or it gets a little bit more, maybe it's a little bit more clear, and you don't need to probate the estate. There's also things like where the beneficiary is already named, right? Then in that situation, you may not need to probate. Or for example, if there is a trust, then you don't need to probate that either. And then of course, something people often ask us is, how long does the probate process take? It's hard to say. It's dependent on each situation, depends on what those assets are, it depends on locating beneficiaries and giving notice to everyone. It depends on whether there's a will contest in place. So it really just depends, but it can take around a year to probate that whole process, probate the estate. So that's a basic of estate planning. I hope that you found this presentation helpful. As a reminder, I am a lawyer with Cobb Legal Aid, and I provide 30-minute consultations to qualifying individuals on qualifying matters every Monday through Wednesday from 9 a.m. to 4 p.m. If you would like to seek legal assistance and advice, please do visit the law library during those times. Thank you.